Good afternoon. Um, I'm very pleased, honored, and privileged to be moderating an exceptional panel. Not many legal panels in legal conferences have the opportunity to have over a round table an ambassador, an appellate justice, a former president of the CCBE, and an acting president of a bar association. So this is a great honor and great opportunity to discuss among esteemed colleagues the best practices in safeguarding the rule of law domestically and internationally in the face of global threats. Allow me to start with short introductory remarks and outline the themes we're going to touch upon. And after that, we'll continue with a short introduction from all our panelists, followed by a Q&A session, so some questions and answers. And I hope through dialogue, we can have the best outcomes. In a world divided by differences of nationality, race, color, religion, and wealth, the rule of law is one of the greatest unifying factors, perhaps the greatest and the nearest we are likely to approach to a universal secular religion. I believe these words, spoken by Lord Bingham, one of the great judges of his generation, perfectly illustrate the value of the rule of law in our legal culture and common legal traditions, at least in the Western world. Today we confront a fundamental question that defines our profession and our democratic future. How do we safeguard the rule of law when it faces threats across multiple fronts? What are the best practices we can draw upon to uphold it? The rule of law is not an abstract ideal. It's a living framework that requires constant vigilance and active protection. From international tribunals to domestic courts, from decisions of independent judges to the advocacy of courageous lawyers, the rule of law depends on all of us. Allow me to share a story which lawyers in Greece are familiar with, but maybe our colleagues practicing abroad are not. Tomorrow, most of you will visit Areospagos. Areospagos is the Court of Cassation, the Greek Court of Cassation. You will find there a copy of a court ruling, a criminal conviction of two heroes of the Greek Revolution, Theodore Kolokotronis and Dimitris Plapoutas. The Bavarian Regency had brought unfounded charges against them for high treason. Despite the efforts and pressure by the then Minister of Justice, two judges among a 5-member panel refused to sign the conviction, Polizoidis and Tertsetis. In the signature block of the ruling, there is a blank space under their names. And Dimitris Fotiadis wrote, "The blanks in the signatures of this ruling are the greatest glory of the Greek legal system." Esteemed colleagues and guests, today's discussion will focus on 3 subjects. First, the international legal order and transnational rule of law. Rule of law claims universal application. Even though enforcement mechanisms differ, it is lawyers' duty to struggle for the implementation of international as well as domestic law. To mention one example, since we have our Cypriot brothers and sisters with us, the illegal occupation of northern Cyprus since 1974 provides a compelling case of how international law can serve both as a shield and as a sword. Despite decades of occupation, the international legal order, through European Court of Human Rights rulings, UN Security Council resolutions, and consistent non-recognition policies, continues to provide Cyprus with powerful legal arguments for reunification and justice. Second, what is the role of lawyers and judges in safeguarding the rule of law in practice? How do we, legal practitioners, defend the rule of law in our daily practice? The Council of Europe recently adopted the Convention for the Protection of the Profession of Lawyer. To my knowledge, this is the first international document of this caliber protecting the profession of lawyer. The convention enshrines the independence of the legal profession, addresses entitlement to practice, professional rights, freedom of expression, professional discipline, and specific protective measures for lawyers, but also for their professional associations, the bar associations. Under the Convention, states must ensure that lawyers can carry out their professional duties without being the target of any form of physical attack, threat, harassment, intimidation, or any improper hindrance or interference. We lawyers need to incorporate this and other legal instruments in our practice to ensure we can exercise our function to the benefits of our clients, but also to society at large. Third, rule of law and democracy. The judiciary represents the rule of law's last line of defense. From adequate funding and security for courts to transparent judicial appointment processes, from digital case management systems that enhance efficiency to legal aid programs that ensure equal access, every element of judicial administration either strengthens or weakens the rule of law. It is our duty to make sure the former prevails. The common thread uniting these axes is this: the rule of law does not and will not defend itself. It requires a collective commitment, will, and courage, and this is a common duty we share. Thank you, and I think touching upon these issues allow me to move to our panelists. Thank you so much. Ambassador Duncan, the floor is yours.
Okay, thank you. Well, firstly, I'd just like to say I feel very humbled to be on a panel with such impressive jurists next to me. And of course, my comments are going to be focused more on the international than the domestic, although the international and domestic are so intertwined that really they are in effect one and the same. We are living in a more dangerous and turbulent world right now. We currently face the greatest risk of nuclear proliferation that the world has faced since the end of World War II. Conflict is raging in all parts of the world. In this part of the world, we feel it very closely, Russia and Ukraine and the Middle East, but you only have to look further south to see Yemen, Myanmar, and other parts of the world that are also locked in conflict. And it's threats such as this that the United Nations was formed to prevent. When we ask ourselves, how are we going to ensure the rule of law in times of conflict, the answer is the United Nations. That's why it exists, so that disputes can be addressed in accordance with international law and norms, and not simply by the power or the size of a country. And in those times when wars do happen, the United Nations and international law is also there. It's there to protect civilians and humanitarian personnel. It's there to safeguard displaced persons and prisoners of war, and to prevent the use of the most heinous weapons. That is what the 193 member states of the United Nations have signed up to. But the international system's under strain. Rules are being broken, international institutions are being eroded, authoritarianism is spreading. It's particularly worrying that misinformation and disinformation are abounding around the world, and we see this in this region. These things are seeking to undermine both international and legal institutions and democratically elected governments. There are more people around the world needing humanitarian assistance. 305 million people this year. That's more than double that number of 5 years ago. There are record numbers of humanitarian personnel being killed. For Australia, best practice in safeguarding the rule of law means combining all the elements of our statecraft. So it's the diplomatic, but it's also the economic, our foreign aid program, and our strategic and military capabilities, combining all of those to push towards the goal of upholding the international rules-based order. But Australia is not a superpower. We can't do it on our own, so we always seek to work in coalitions. We cooperate deeply in our own region through groupings like ASEAN and the Pacific Islands Forum. obviously with more traditional partners, such as the UK, the US, Canada, and New Zealand. But more important, well, not more importantly, but increasingly and importantly, with more non-traditional partners as well. We need cross-regional and north-south support for these aims because there's no point trying to uphold a global rules-based order if only one part of the globe wants to do so. We have to work with non-traditional partners as well. One example of how Australia's doing this is through our leadership in drafting a declaration for the protection of humanitarian personnel. This is something that our Foreign Minister announced at last year's UN General Assembly High-Level Week in September last year to say that Australia would lead in the drafting of such a declaration. Since then, we formed a ministerial group with Jordan, Switzerland, Indonesia, Sierra Leone, the UK, Japan, Brazil, and Colombia. There's no accident in that choice of countries. They were deliberately chosen to represent diverse global perspectives. We've been working away on a declaration, which is almost ready. And the purpose of the declaration is to translate political commitment into practical and actionable steps to protect aid workers in conflict zones. There were more than 360 aid workers killed in conflict zones last year alone, and many more injured. Now, this will be a non-binding declaration, but the idea of it is to galvanise political pressure to promote compliance with existing legal frameworks. We intend to launch the declaration at the High-Level Week this year in September, and we look forward to Greece's support and many other countries for the declaration once it's tabled at the UN. So that's it for my opening remarks. Thank you.
Thank you so much, Ambassador. Thank you so much. Mr. Perakis?
Ευχαριστώ πολύ. For those who don't speak Greek, I apologize. I'm going to speak in Greek. Being in Greece, in Athens, we decided to keep it as a working language, even partially. So, λοιπόν, αφού ευχαριστήσω πάρα πολύ για αυτή την πρόσκληση, εγώ θα προσεγγίσω λίγο διαφορετικά το θέμα. Ποιες είναι, κατά τη γνώμη μου, οι απειλές για να δούμε και τις best practices. Νομίζω ότι οι απειλές που είναι αυτά που είπε η κυρία Πρέσβης πριν από λίγο, θα προσπαθώ να το κάνω λίγο πιο σχηματικά. Η πρώτη και μεγαλύτερη που αντιμετωπίζουμε αυτόν τον καιρό είναι μια διάθεση περιφρόνησης του δικαίου ή υποβάθμισης του δικαίου εις όφελος της δύναμης. Αυτό δημιουργεί ένα πρόβλημα στον αξιακό μας κώδικα, στον κώδικα πάνω στον οποίο στηρίζεται η ίδια ύπαρξη του κράτους δικαίου. Αυτό είναι, κατά τη γνώμη μου, η μεγαλύτερη απειλή. Το βλέπουμε με αυτά που συμβαίνουν στην Αμερική, το βλέπουμε με την εισβολή της Ρωσίας και σε τόσα άλλα μέρη του κόσμου. Η δεύτερη μεγάλη απειλή είναι η κίνδυνη από την τεχνολογία σε συνδυασμό με τα social media και κυρίως με την τεχνητή νοημοσύνη. Υπάρχουν δυνατότητες τεράστιες, κυρίως να κλονίσουν την εμπιστοσύνη των πολιτών στους θεσμούς. Η τρίτη μεγάλη απειλή, κατά τη γνώμη μου, έχει να κάνει με τη δικαιοσύνη, με το κόστος πρόσβασης στη δικαιοσύνη και το χρόνο απόδοσης της δικαιοσύνης, που και αυτό μπορεί να κλονίσει την εμπιστοσύνη των πολιτών στους θεσμούς. Και το τέταρτο είναι αυτό που έχω πει ήδη 2-3 φορές. Η μεγαλύτερη απειλή είναι να χαθεί η εμπιστοσύνη των ανθρώπων στο κράτος δικαίου και στους θεσμούς του. Τι θα μπορούσαμε να... Και αν σκεφτείτε, είναι εντυπωσιακό ότι αυτά τα 4 πράγματα που είπα, έτσι λίγο κατηγοριοποιημένα, είτε τα συζητήσουμε σε μια μικρή ελληνική επαρχιακή πόλη, είτε τα συζητήσουμε στην Αυστραλία, είτε στην Κύπρο, είτε στην Αμερική, είτε στην Ιαπωνία, θα σας πω εγώ, με δική μου εμπειρία, λίγο πολύ θα συμφωνήσουμε όλοι ότι αυτά είναι πλέον παγκόσμιες οι απειλές. Τι κάνουμε? Νομίζω το πρώτο που πρέπει να κάνουμε είναι να αρθρώνουμε λόγο, ειδικά εμείς οι νομικοί, οι δικηγόροι και οι δικαστές, και να πανεβαίνουμε στα μεγάλα θέματα που απασχολούν τον κόσμο ή τις χώρες μας. Και να παρεμβαίνουμε με κάθε τρόπο που μας επιτρέπει το δίκαιο. Παραδείγματος χάρη, το κάναμε ως CCBE, ως Ευρωπαίοι δικηγόροι, απευθυνθήκαμε την πρώτη κιόλας μέρα της ρωσικής εισβολής στο Διεθνές Ποινικό Δικαστήριο. Το κάναμε, συνεργαστήκαμε με την Ευρωπαϊκή Επιτροπή για τις κυρώσεις. Αξιοποιούμε κάθε τι. Το δεύτερο που πρέπει να κάνουμε είναι να πάμε ένα βήμα πίσω και να προσπαθήσουμε σε αυτή την πραγματικότητα στην οποία πρέπει να έχουμε λόγο τεκμηριωμένο, αποφεύγοντας τις φωνές, αποφεύγοντας τις κραυγές, διότι οι κραυγές είναι το όπλο των απέναντι, του δικαστικού λαϊκισμού. Εμείς πρέπει να έχουμε ένα λόγο ήρεμο και τεκμηριωμένο. Νομίζω ότι οι κραυγές κάνουν κακό σε όσους πιστεύουν στο κράτος δικαίου. Το δεύτερο που έχουμε να κάνουμε είναι να συνδιαμορφώνουμε τα πράγματα, την πραγματικότητα. Πώς θα το κάνουμε αυτό? Συμμετέχοντας όσο μπορούμε στη διαμόρφωση των νέων κανόνων, στα νέα ρυθμιστικά πλαίσια που κανονίζουν τις ζωές μας και όλο και περισσότερο ρυθμίζουν τις κάθε είδους δραστηριότητες. Το κάνουμε τώρα, ας πούμε, που συζητείται σε επίπεδο Ευρωπαϊκής Ένωσης, το Cloud and AI Development Act, που είναι κάτι πάρα πολύ σημαντικό, για την Ευρώπη ακόμα σημαντικότερο. Αν δεν ξέρετε, θα σας πω ότι το 92% των παγκόσμιων αποθηκευμένων δεδομένων είναι σε κάποιες λίγες αμερικάνικες εταιρείες. Καταλαβαίνετε τι ανισότητες μπορεί να δημιουργήσει αυτό και τι εξαρτήσεις εις βάρος του κράτους δικαίου. Το κάναμε πετυχημένα στο GDPR, που είχαμε πολύ μεγάλη ως δικηγόροι συμμετοχή στη διαμόρφωση του τελικού κειμένου. Νομίζω ότι δεν το κάναμε πολύ καλά στο AI Act και σε ό,τι γίνεται σε επίπεδο τεχνητής νοημοσύνης στον κόσμο. Θεωρώ ότι ως νομικοί θα πρέπει να είμαστε πιο μπροστά, πιο μαζί στις εξελίξεις, διότι αν δεν διαμορφώσουμε εμείς τους νέους κανόνες που να σέβονται το κράτος δικαίου, ποιος άλλος θα το κάνει? Κανείς. Εμείς πρέπει να το κάνουμε και νομίζω ότι έχουμε μείνει λίγο πίσω εκεί. Το τρίτο που θεωρώ ότι πρέπει να κάνουμε είναι να υπερασπιστούμε το ρόλο μας, την υπόστασή μας. Δηλαδή να υπερασπιζόμαστε με κάθε αφορμή την ανεξαρτησία μας, το επαγγελματικό απόρριτο και το θεμελιώδες δικαίωμα πρόσβασης κάθε ανθρώπου σε δικηγόρο, γιατί χωρίς αυτό δεν υπάρχει δικαίωμα πρόσβασης στη δικαιοσύνη. Επίσης, υπερασπιζόμαστε το ρόλο μας όταν προσπαθούμε να συνεχίσουμε να είμαστε χρήσιμοι στην κοινωνία. Και είμαστε χρήσιμοι στην κοινωνία και ζητώντας αυτά που έχει ανάγκη, παραδείγματος χάρη νομική βοήθεια, ένα πολύ μεγάλο θέμα. Να έχουν όλοι οι άνθρωποι, αυτοί που δεν έχουν τους πόρους, δικαίωμα πρόσβαση σε δικηγόρο. Αλλά και κυρίως παρέχοντας διαρκή εκπαίδευση σε όλους τους νομικούς. Δεν θα είμαστε χρήσιμοι στην κοινωνία αν δεν ξέρουμε να μιλάμε τι γίνεται σήμερα. Αν δεν ξέρουμε τα νέα παιδεία, αν δεν ξέρουμε να χειριζόμαστε εμείς όλοι την τεχνολογία, θα πάψουμε να είμαστε χρήσιμοι. Και το τελευταίο, θα μπορούσα να πω και άλλα ίσως στη συνέχεια, είναι πέρα ότι υπερασπιζόμαστε το ρόλο μας, πρέπει να υπερασπιζόμαστε κάθε μέρα και το κράτος δικαίου. Έχω παρατηρήσει ότι ακόμα και πολλοί από εμάς, ακόμα περισσότερο πολλοί στην κοινωνία, δεν ξέρουν τι είναι το κράτος δικαίου. Ειλικρινά δεν ξέρουν τι θα πει φιλελεύθερη δημοκρατία. Δεν ξέρουν, ας πούμε, ότι η φιλελεύθερη δημοκρατία είναι ελεύθερες εκλογές, θεμελιώδη δικαιώματα που δεν υπακούν σε κανόνες πλειοψηφίας και μειοψηφίας και θεσμοί του κράτους δικαίου, θεσμικά αντίβαρα. Αυτά πρέπει να τα εξηγήσουμε στον κόσμο, πρέπει να τα κατανοήσουμε εμείς οι ίδιοι. Γιατί? Διότι ό,τι έχω πει ως τώρα αφορά κυρίως τη συλλογική δράση, τους δικηγορικούς συλλόγους σε εθνικό και διεθνές επίπεδο, συνεργασίες, δίκτυα, παρατηρητήρια δικαιοσύνης, αλλά αυτό μπορεί να το κάνει και ο καθένας από εμάς στην καθημερινή του πράξη. Και γι' αυτό θεωρώ ότι στην υπεράσπιση του κράτους δικαίου η βέλτιστη πρακτική είναι να προσπαθούμε εμείς κάθε μέρα, τηρώντας κυρίως τη διοντολογία, να γινόμαστε καλύτεροι και να γινόμαστε ένα παράδειγμα, ζωντανό παράδειγμα ο καθένας από εμάς του κράτους δικαίου. Ξέρετε, εγώ είμαι οπαδός, όπως ξέρουν οι φίλοι μου, της θεωρίας προσωπικής ευθύνης. Και γι' αυτό δεν θεωρώ ότι για να σώσουμε τον κόσμο πρέπει να κάνουμε μεγαλεπίβολα πράγματα κάθε μέρα, να λύσουμε το Παλαιστινιακό. Όχι. Πιστεύω όμως ότι σώζουμε τον κόσμο κάθε μέρα, αν κάνουμε κάθε μέρα σωστά τη δουλειά μας. Ευχαριστώ.
Ευχαριστούμε πολύ τον κύριο Περάκη. Justice Voutsinas.
Good afternoon, everyone. I want to thank everyone for staying and listening to us at this hour. I am honored to be here in the country of my where my family came from and went to New York, and where I feel at home, in Timimu. And I just wanted to thank everyone for the invitation to speak at this auspicious event with distinguished panelists. I just want to let you know, I just want to speak about the court I sit in a little bit, just for comparison. I sit on the Appellate Division, Second Department in New York State, which covers 10 counties, serving approximately 10 million people, and it represents half of the population in New York State. The New York State Second Department handles the largest caseload of appeals in the nation, not only in New York, but in the nation. And it's larger than its three counterparts. We have this joke in the second department that we have no problem telling the first department that the second department is second to none. Um, so we also, not only do we hear appeals, but we also are in charge of grievances and admissions. So there's been times as a new judge where I invited law students to come in when they were getting admitted, and I take them and I give them a tour of the courthouse, and I show them that the room that they're about to be sworn in with their family, and everybody is so proud and excited to see the second department where they're about to take the oath to become an attorney. And then I take them up to the second floor, and I tell them that after they're sworn in to take the oath by a panel of 4 judges, the 24 judges that sit at the second department will sit around this huge table, probably the size of this stage, and they will vote on disciplinary proceedings of attorneys, which are either to just give them a reprimand or to disbar them and take their license away. And that is something that we take very seriously. I tell them we grant admissions to the bar and we take it away through a process. And we have an entire department, an entire building committed to working on those cases, um, to make sure that attorneys that are admitted are qualified, that they're ethical, and that they have the utmost integrity. And I believe this is a fundamental process and the first step in safeguarding the rule of law, because it starts with every single one of you and comes to when you come before the judiciary. So I know we've been talking a lot about the judiciary, which obviously goes without saying, but it also starts with each attorney that practices law and sees the people in our community. So, in addition to hearing appeals, the appellate division hears all the cases from the lower courts, including felony criminal cases, civil litigation, family and matrimonial law, mandamus, and certiorari review. We sit on a panel of 4 because we have the largest caseload. You must say what happens when there is a split, a 2-2. We've had that. We call in a 5th judge, and they break the tie. So we are a precedential court. We follow precedent, and it is only when an issue that hasn't been heard that we are a case of first impression. I am thrilled to talk about best practices in the rule of law to ensure justice for people. I take it very seriously, and I'm really interested in listening to this panel and sharing my thoughts as an appellate division judge as far as how we can institute those best practices in our daily practice. So thank you.
Thank you so much, Justice Voutsinas.
Thank you, George. Before diving into the issue, I would also like to thank everybody that's contributed in organizing this global summit of Hellenic lawyers. It's great privilege and honor to be here amongst so many co-Hellenes from around the world, and having the benefit of being on day 3. I think I speak on behalf of all my colleagues from Cyprus in saying that this event is an amazing opportunity to exchange views, and hopefully it will become an institution. I have the honor to be the president of a bar association in Cyprus, which is in exile due to the ongoing foreign occupation of Cyprus since 1974 by Turkey. The Kyrenia Bar Association, which I preside, is actually the only local bar association in Cyprus which the entirety of its district is still under occupation. Being so, both the Kyrenia Bar Association and the Cyprus Bar Association, of which it is an integral part of, have always been at the forefront of discussions and in promoting the upholding of international law, safeguarding human rights, and promoting, of course, the rule of law. Safeguarding the rule of law, both domestically and internationally, is central for maintaining justice, peace, accountability, and democratic governance. In an era of global threats such as military conflict, terrorism, authoritarianism, disinformation, and technological misuse, the challenge has definitely become even more complex. Both domestic resilience and international cooperation are essential. We should remind ourselves why the rule of law matters and what its core principles are: equality before the law, legal certainty and transparency, judicial independence, and accountability. I would like to echo what the ambassador said. The UN is our global legal house, and violations of public international law by numerous states have diminished the rule of law on the ground and domestically too. The role of international law and of the UN Charter post World War II is a very topical issue, and I think us lawyers have to also engage in this discussion and make various conclusions. The lack of enforcement mechanisms has definitely led states to disregard international law. The world has departed from multilateralism, and the international legal order has to be reformed and re-established. There's a lot of discussion about the Security Council membership and if other countries should join the Security Council as permanent members, veto powers, if a parliamentary assembly of the UN should be elected by the peoples, electing the Secretary General directly by the people around the globe. This discussion is very crucial and important in the days where we're living. We can see that the UN is playing little role for peace and security the last years, which is supposed to be its prime purpose. Recent examples are Syria, the Russian invasion in Ukraine, the ongoing conflict in Gaza, and others. The Deputy Minister for Migration and International Protection, Dr. Ioannidis, this morning made a comment that I wish to echo again. Humanity has made so much progress over the last 100 years, and definitely post World War II, in setting up the UN in the aftermath of the catastrophe of World War II. We cannot let humanity reach that stage again, and it's very important for us lawyers to also engage in this discussion, to both domestically and internationally, and within our communities, to find the way for the UN to remain the hub of well-established norms, as are the rule of law and the respect of human rights. Thank you.
Thank you so much. Thank you all for great introductory remarks regarding both international and domestic aspects for protection of rule of law and the role of lawyers there too. Allow me now to start a Q&A session. So the idea of the panel is to have an exchange on views among us. So I'll start with you, Ambassador Duncan. You have had an extensive experience throughout most aspects of the Department of Foreign Affairs, the trade portfolio, trade and investment, international security. So you've got a vast experience. Could you share some views or provide some examples of how Australia has contributed to peace building and to security precisely through the application of international law, so using the international law as a means to achieve those goals?
Sure, thank you. Well, I think put simply, there are three ways that we can contribute to peace building and security through applying international law, and that's through contributing to strong institutions, by implementing international law, and by advocacy. It sounds a bit simple, but in terms of the institutions themselves, Australia's always been a very strong supporter of the UN. We were there from the beginning. We were particularly involved in the drafting of the Universal Declaration of Human Rights. We are strong supporters of the International Court of Justice and the ICC. We contribute to UN agencies, and we're bidding to become a non-permanent member of the UN Security Council for the 2029-30 term. It's inherent in Australia's DNA, I think, to support international institutions. In terms of implementing international law, we've also got a very strong record of implementing treaties into domestic law, and we've got quite a few Australian judges in the room who I'm sure will attest that when the government is recalcitrant or less motivated in implementing international law, the courts do it for us. That happens in Australia if the government fails to adhere to international law through legislation. The courts will remedy that. So we have a very strong court system, and I'm not just saying that because our Chief Justice is in the room. And then finally, there's advocacy. So Australia joined the 140 countries to demand Russia's withdrawal from Ukraine in February 2023 at the UN General Assembly. But we back that up with action as well. Australia is the biggest non-NATO military contributor to Ukraine in supporting Ukraine against Russia's war of aggression. In the Middle East, we've joined the international community in calling for a ceasefire, for release of hostages, for the protection of civilians, and in terms of the need for a two-state solution. We're using our term on the UN Peacebuilding Commission this year to work towards these kinds of goals. But we also use our $5 billion international development program to promote the rule of law and adherence to international law. Particularly in the Indo-Pacific, which is where we concentrate the bulk of our international development effort. We have very strong law and justice programs across the Pacific in particular. In fact, part of my own experience was working in Solomon Islands when Australia was leading a regional peacekeeping mission there called the Regional Assistance Mission to Solomon Islands. The unique thing about that mission was that Australia was the lead country and we did pay 94% of the costs of the mission, but it involved 15 countries. Every country of the Pacific Islands Forum contributed to that mission, including the tiny country of Niue that has a population of 10,000 people. They contributed 2 of their 10 police officers to that mission. And it was amazing because it rebuilt the law and justice sector of Solomon Islands, which had been completely destroyed, really, during an ethnic civil war and as well as other government institutions, and working to rebuild the economy as well. So, practical actions like that, working in concert with partners, is how Australia approaches peace building. It's all very well to talk about advocacy and saying things in the UN and demanding accountability. It's also easy to say, well, what does it matter if the war continues or the aggression continues? The point of international law and of the UN is that a single country can't do this alone. If Australia is the only country, or Greece or Cyprus or the US is the only country demanding adherence to international law, it's unlikely to succeed. But if the united weight of global voices are calling for the same thing, then we have to have some confidence that it might make a difference. And that's why Australia continues to be a strong advocate of these issues, both in multilateral forums and bilaterally.
Thank you. Thank you so much for providing concrete examples showing that when there is political will, then state actors can also enforce collectively rule of law at the international level. Thank you so much. Κύριε Περάκη, είναι γνωστό ότι έχετε μια συνεπή δημόσια παρουσία στα θέματα υπεράσπισης του κράτους δικαίου μέσα από πολλούς ρόλους και στο Διοικητικό Συμβούλιο του Δικηγορικού Συλλόγου Αθηνών και στο Συμβούλιο των Δικηγορικών Συλλόγων Ευρώπης ως πρόεδρος και μετά τα αυτά ήδη με το Παρατηρητήριο Δικαιοσύνης, μια πρωτοβουλία που αναλάβατε ακριβώς σχετικά με την παρακολούθηση και κυρίως την ανάδειξη στη δημόσια σφαίρα, των ζητημάτων που ταλανίζουν την ελληνική δικαιοσύνη, χρόνιες παθογένειες που χρειάζονται μια συλλογική αντιμετώπιση. Με δεδομένο ότι έχετε μια εκτεταμένη διεθνή εμπειρία, μπορείτε να μας πείτε αν υπάρχουν εξελίξεις σήμερα σε διεθνές επίπεδο που δικαιολογούν έστω κάποια αισιοδοξία? Γιατί μέχρι τώρα έχουμε εστιάσει κυρίως στις απειλές, στους κινδύνους. Το ερώτημα είναι αν υπάρχει κάποια αχτίδα αισιοδοξίας μέσα στο δυστοπικό περιβάλλον που βιώνουμε και περιγράφουμε δικαίως όλοι μας.
Ναι, ευχαριστώ πολύ για τα καλά σας λόγια. Νομίζω ότι μπορούμε να είμαστε αισιόδοξοι. Υπάρχουν αχτίδες αισιοδοξίας. Παραδείγματος χάρη, η έκθεση κάθε χρόνο του ειδικού εισηγητή του ΟΗΕ για το δικηγορικό επάγγελμα, η οποία καταγράφει φυσικά τα μεγάλα προβλήματα που αντιμετωπίζουν κάποιοι νομικοί σε όλο τον κόσμο που αγωνίζονται για το κράτος δικαίου, αλλά υπογραμμίζει την κρίσιμη σημασία του δικηγορικού επαγγέλματος στη διατήρηση του κράτους δικαίου. Ένα δεύτερο παράδειγμα, το είπατε εσείς στην αρχή, που είναι πάρα πολύ σημαντικό διεθνώς, είναι η θέσπιση της Σύμβασης για την Προστασία του Επαγγέλματος του Δικηγόρου από το Συμβούλιο της Ευρώπης. Ήδη επικυρώθηκε παραπάνω από τις χώρες που έπρεπε για να μπει σε ισχύ. Νομίζω από την 1η Σεπτεμβρίου μπαίνει σε ισχύ. Είναι ένα πολύ μεγάλο βήμα που ξεπερνάει σε σημασία και τα μέλη του Συμβουλίου της Ευρώπης. Ήδη παρουσιάσατε βασικές προβλέψεις αυτής της σύμβασης. Θα προσθέσω εγώ μία για να καταλάβουμε πώς αυτό επηρεάζει και την καθημερινή μας ζωή σε εθνικό επίπεδο. Η σύμβαση αυτή έχει ειδική πρόβλεψη, αν δεν κάνω λάθος, στο άρθρο 7, που κατοχυρώνει την αρμοδιότητα, το ένομο συμφέρον των δικηγόρων και των δικηγορικών συλλόγων να ασχολούνται με πράγματα που αφορούν όχι μόνο στο επάγγελμά τους ή στη δικαιοσύνη, αλλά στο κράτος δικαίου εν γέννη. Υπάρχει ρητή πρόβλεψη. Αυτό σημαίνει ότι αν ήταν σε ισχύ, όταν κουβεντιάζαμε στο Συμβούλιο της Επικρατείας εδώ στην Ελλάδα την προσφυγή του Δικηγορικού Συλλόγου για το θέμα του σωστού ή όχι διορισμού κάποιου μέλους μιας ανεξάρτητης αρχής, η οποία απορρίφθηκε λόγω έλλειψης ενόμου συμφέροντος, αυτό δεν θα μπορούσε να συμβεί. Ένα άλλο συγκεκριμένο παράδειγμα που μπορώ να σας δώσω από δικαιολογία αισιοδοξία είναι η νομολογία του Δικαστηρίου της Ευρωπαϊκής Ένωσης και του Δικαστηρίου του Στρασβούργου, αλλά αυτό που έχει σημασία είναι του ΔΕ. Υπάρχει μια πολύ πρόσφατη απόφαση, βγήκε τελευταίες μέρες του 2024, η οποία λέει ότι η αρχή της ελεύθερης εγκατάστασης και οι αρχές και της ελεύθερης κίνησης των κεφαλαίων στην Ευρωπαϊκή Ένωση δικαιολογείται να μην τηρούνται και να έχουμε εξαίρεση σε αυτές όταν πρόκειται για το επάγγελμα του δικηγόρου, για τη διαφύλαξη του επαγγελματικού απορρίτου και της ανεξαρτησίας τους και έτσι αποφάσισε το δικαστήριο ότι είναι επιτρεπτή η απαγόρευση συμμετοχής σε δικηγορική εταιρεία χρηματοπιστωτικών ιδρυμάτων. Διότι θεώρησε το δικαστήριο με μια εκπληκτική αιτιολογία ότι αυτό μπορεί να επηρεάσει την ανεξαρτησία των δικηγόρων και την υποχρέωσή τους για σεβασμό στο επαγγελματικό απόρριτο. Άρα θέλω να πω ότι υπάρχουν συγκεκριμένα δεδομένα που μπορούμε να είμαστε αισιόδοξοι, που διατηρούν την ελπίδα ότι μπορούμε να συνεχίσουμε να αγωνιζόμαστε για το κράτος δικαίου. Φυσικά πρέπει να κάνουμε πάρα πολλά ακόμα. Πρέπει να είμαστε ενεργοί και πιο ενεργοί σε θέματα, παραδείγματος χάρη, στο ετήσιο Rule of Law Report της Ευρωπαϊκής Ένωσης που συμμετέχουμε. Μπορούμε να το κάνουμε ακόμα καλύτερα και πιο τεκμηριωμένα. Είπα πριν και νομίζω ότι πρέπει να κάνουμε πολλή δουλειά στα θέματα της τεχνητής νοημοσύνης. Είχα μια καλή συνεργασία με την Ντέβορα Ένις Ρος, που ήταν η πρώην πρόεδρος του ABA, που είναι ο μεγαλύτερος δικηγορικός σύλλογος του κόσμου, ο Αμερικάνικος, και με την κυρία Σμιθ, που οι Αμερικάνοι συνάδελφοι κάνουν πολλή δουλειά. Πρέπει να κάνουμε και άλλα σε όλο τον κόσμο. Πρέπει να κάνουμε προτάσεις για να κάνουμε τη δικαιοσύνη καλύτερη. Πρέπει να είμαστε αλληλέγγυοι. Το κάναμε πολύ καλά στην Πολωνία. Όπου χρειάζεται το κράτος δικαίου η υποστήριξη, πρέπει να είμαστε εκεί. Υπάρχουν συνάδελφοι που αγωνίζονται μόνοι τους στην Κίνα, στη Ρωσία. Πρέπει να είμαστε δίπλα τους. Πρέπει να λέμε και τα δύσκολα. Παραδείγματος χάρη, το μεταναστευτικό και το προσφυγικό. Είναι δύσκολα θέματα, αλλά και εκεί πρέπει να εξηγούμε και να υπερασπιζόμαστε αρχές του κράτους δικαίου. Ξέρετε, για τον πολύ κόσμο, είπα πριν ότι δεν καταλαβαίνει τι είναι το κράτος δικαίου ή δεν ξέρει. Εγώ θα πω τώρα κάτι παραπάνω. Δεν υποστηρίζει εύκολα τις αρχές του κράτους δικαίου. Είναι δύσκολο ο απλός πολίτης να καταλάβει το τεκμήριο αθωότητας. Είναι πάρα πολύ δύσκολο να καταλάβει και να σταθεί απέναντι στην ποινή του θανάτου. Δεν του αρέσει καθόλου η παραγραφή. Αυτά πρέπει να του τα εξηγήσουμε εμείς. Είναι δική μας δουλειά. Άρα αυτό που λέω εγώ στην ερώτησή σας, ναι, υπάρχουν πράγματα που μπορούν να μας κρατούν αισιόδοξους, αλλά πάνω σε αυτά βασιζόμενοι πρέπει να κάνουμε πολλά και κυρίως να μιλάμε, γιατί η φωνή μας έχει σημασία. Ευχαριστώ.
Ευχαριστώ πολύ για τις κέρυες παρατηρήσεις. Η αλήθεια είναι βέβαια, επειδή αναφερθήκατε και στην απόφαση του Συμβουλίου Επικρατείας σε σχέση με την πρόσφατη διεθνή συνθήκη, η αλήθεια είναι ότι τα άρθρα του κώδικα δικηγόρων, το 90 και το 131, έχουν μάλλον ευρύτερη διατύπωση από τη συνθήκη. Και νομίζω αυτό μας δείχνει ότι όταν οι διατάξεις συγκρούονται με την νομική βουλησιαρχία, δεν είναι βέβαιο ότι κερδίζουν οι διατάξεις.
Αλλά θα έχει και υπερεθνική ισχύ.
Βεβαίως έχει υπερεθνική ισχύ, αλλά δεν ήταν θέμα συνταγματικότητας. Αυτό είναι το πρόβλημα. Δεν τέθηκε θέμα συνταγματικότητας. Απλώς κρίθηκε για πρώτη φορά με ανατροπή παγίας νομολογίας ότι οι δικηγορικοί σύλλογοι δεν έχουν ένομο συμφέρον για ένα προφανές ζήτημα που αφορά τη δικαιοσύνη και εμπίπτει σε όλες τις διατάξεις και του κώδικα δικηγόρων και τις διατάξεις υπερεθνικής ισχύως. Κρατάμε όμως τη σημασία του ρόλου των δικηγόρων προκειμένου να εμπεδοθούν οι αρχές του κράτους δικαίου στην κοινωνία, και νομίζω ότι είναι σημαντικό να το αναδεικνύουμε, γιατί πολλές φορές κοιτάμε ενδοστρεφώς μόνο τα ζητήματα αυτά ως νομικό επάγγελμα, ως δικηγορικό σώμα, και είναι πολύ σημαντικό το άνοιγμά μας στην κοινωνία και η διάδραση με την κοινωνία. Justice Voutsinas, before I ask you a question, because you have had extensive judicial experience and you have also held numerous administrative posts at a very high level, at this point in Greece, judicial appointments have been an issue of public discourse. So before asking you the main question I wanted to ask you, could you please just describe, mainly for the Greek audience, what was your path to becoming an appellate justice?
Well, it was certainly an interesting path. It was a surprising path. Like many of the people here who have come here from New York, you know, my father went to New York. My parents went to New York for a better life. They went there with nothing, and they hoped and they instilled education. So for me to become a judge in the United States and in New York State was not something that I could ever have dreamed of. It was not reachable. When I went to law school was was a challenge. You know, graduating law school, becoming a lawyer, that was going to be the success in my family because that's a huge success. That's unbelievable. So, you know, to make it to the appellate division and the Court of Appeals, Madeline Singas, I mean, she's our pride in New York State. It is a big deal coming from immigrant parents, coming from, you know, um, means that are not in the pedigree, as Judge Singas had said, is something to be spoken of. So I started off as an attorney in a private law firm. I had decided to go into government and take a pay cut and become a assistant town attorney and learn about government, and I was deputy counsel to the legislature at one point. I then became principal law clerk to a judge. I was that for quite some time, 7 years, learning. We were in Supreme Court and felony court for criminal cases. And at the age of 35, I saw an opportunity to run for judge. So like Judge Singas had said, it's a hybrid in New York State. Some positions are elected, some are appointed. They go through a rigorous process. You have to go for screening before the Bar Association. They ask questions at the Bar Association that are challenging. You know, when I first went for screening, I was 35 years old. A lot of the practitioners had known me because they had practiced in front of my judge. Some people had, their own opinions of me, but you're found qualified or not qualified. I was found qualified every single time I went to the screening committee because I had gone there numerous times. But I first started in the district court, which is the lowest court. It's the township of Hempstead, which is 1 million people, and it's elected. And um, I don't think I was, it's done by party at that time. And I don't know if I was the party pick, but I won an election with the majority of the votes. I then was a judge for 8 years in the district court. I was in domestic violence, DWI part, a trial part, and it was just being able at that point to be a good judge, to bring integrity to the bench, to be fair, to show that you can hear cases and apply the rule of law. And there was an opportunity to run for Supreme Court. To become an appellate division judge, you must be elected to a Supreme Court position. And that comes with my judicial district falls within 2 counties, which is 3 million people. So I was elected to the Supreme Court. Also, rigorous process. You go before the bar associations, and you have to be found qualified. But it is elected. And then the appellate division is a process where anybody can apply to be considered for this position. You apply to the position, you go before the screening committee, and then names are put forth to the governor, and she appointed me as I was one of the first appointments by the governor. She was the first female governor, and I was one of her first appointments. So it was a hybrid. So I don't know what the answer to that is, but I can say that at the time that I first started, I don't know if I would have been a judge when I won my election in 2010 if it was an appointed position. So it was the people. It was the people that elected me to that position at the time, but that opened the door for further elections. So there is an argument by the bar associations and New York, we are big on diversity and inclusion and equal justice. There is an argument that without elected races, that there is no opportunity for someone to come from the outside to get on the ballot if it's a closed process of appointment.
So So that's an amazing path to start with, and then from an institutional point of view, I understand that there is a screening committee from the bar associations and an election process, followed by an appointment.
Correct. For the appellate division.
Right. Yes.
All the
Yes.
four appellate
Exactly.
divisions.
It's very. It's in stark contrast with our system of career judges, which is completely different.
Right, and that's very different from the Court of Appeals, where Judge Singh sits, where that is strictly appointed. It's a screening committee by the Judicial Screening Committee, and it's appointed by the governor,
By the governor, so by the executive.
by the executive.
That again, that is a very debated issue in Greece. The interplay between the executive and appointments by the executive of justices, Supreme Court justices in Greece. But it's very interesting. I mean, that's a great insight. And since you brought up the issue of access to justice, um, uh, uh, the United States is notorious about having very expensive justice. Are they? What kind of programs of access of justice programs do you have in New York for those that do not have the means?
Well, New York State, the forefront of the court system is access to justice. I think I hear that term daily. Access to justice is quite important. And I don't speak for the chief, so I hope this I don't speak for the chief at all, because it's the chief that initiates the Access to Justice program. It's one of the initiatives in the New York State Judiciary that promotes the rule of law by expanding access to legal services and institutions across various parts of society, regardless of their background, income, or ability. So, how do they do that? It's so multifaceted. Um, they have a whole team working on it. They support pro bono attorneys, which is the legal aid that has been mentioned as being quite important to make sure that that everyone has access to an attorney, that everybody's represented. And then there's self-help services. So each county, I actually sit on the Access to Justice Committee in Nassau County, where I come from, and we make recommendations to the county and to the state in what we think will help and open the doors to make sure that nobody is turned away, or everybody has an ability to know the process. So there's self-help services. We've had forms put on the internet. We've tried to explain things, use technological tools on the internet, and endeavor to secure stable and adequate nonprofit and governmental funding for civil legal services. Um, so access to the legal information deepens our understanding of the core process and empowers court users to engage, I believe, in meaningful court interactions, and makes it easier for both the person that is coming into the court and all the stakeholders involved. And in addition to those initiatives, the Access to Justice initiatives, they've instituted youth and emerging adult division with youth getting in trouble, the Child Welfare and Family Justice Division, the Office of Diversity and Inclusion, which is multifaceted effort committed to rooting out all forms of bias and discrimination in our courts, because that's really an important issue in New York, and judiciary, civil legal services. One thing that is interesting is this Access to Justice and the Office of Justice Initiatives has instituted an inspector general. So it's a independent office that hears complaints of bias and harassment within the court system. So if there's an employee that speaks poorly to someone coming in, a litigant into the courthouse, and there's a complaint, there's an actual investigation that occurs within the court system, and there are consequences. So these are the ways that um, we believe that the rule of law uh, continues through having the opportunity and the ability to have access to justice. We also have recommended that, and I know that you think of judges and the integrity, and while keeping the integrity of judges, but having judges go out and talk in the community and talking to people in schools and places of worship, and people getting to know the judges and having faith, having confidence in the person that you are appearing in front of, that they're following the rule of law. So these are all in the fundamental, these go to the fundamental services that the court offers. I hope I answered your
Thanks
question.
so much. That was very helpful, and it helps us understand how the system works in the United States at the state level, which is for which we have much, visibility is not the same as the federal level. Thank you so much. President Constantinides, you are president of the Kyrenia Bar Association, a member of the board of the Cyprus Bar, a practicing attorney. Cyprus having the unique situation of the occupation for more than 50 years now. Could you please elaborate on what have been the challenges for the rule of law in Cyprus, taking into account this unique situation?
Yes, thank you, George, for the question. Notwithstanding the weakening of the influence of the UN setup that we mentioned before, in the case of Cyprus, historically, international law has safeguarded the Republic of Cyprus's status. I think we can say safely that Cyprus is a paradigm of legal resilience. Even from 1963, just 3 years after Cyprus gained its independence, there was a departure of the Turkish Cypriot community from all the institutions of the Republic, but it was international law that safeguarded the Republic of Cyprus as a subject of public international law. Security Council Resolution 186 of 1964 provided that the government of Cyprus, even without the participation of the Turkish Cypriot community, was still legitimate and the only recognized government in Cyprus. Constitutional and domestic legal order was preserved with the doctrine of necessity. In Latin, it's salus populi suprema lex esto, which is the welfare of the people, is the supreme law, a legal norm that has kept Cyprus in legal tax for the last 61 years. It was a decision of the Supreme Court of Cyprus. So it's to a testament of our judges in 1964 giving that ruling and maintaining constitutional order in Cyprus. Of course, Cyprus has also suffered a brutal invasion in 1974 and an ongoing occupation till today, which gave rise to gross violation of human rights, the rule of law, and the legal order. But there is a number of councils, Security Council resolutions condemning the Turkish occupation and invasion, and have also kept the Republic of Cyprus in full sovereignty over the island, as the proclamation of the so-called Turkish Republic of Northern Cyprus has not been recognized and is banned by the relevant Security Council resolutions. Cyprus has consistently turned to international legal mechanisms for redress, notably the Didina Loizidou case against Turkey, a refugee from Kyrenia, and the various interstate cases between Cyprus and Turkey before the European Court of Human Rights. And I think these landmark cases and Cyprus's consistency via various international legal remedies does showcase how a small state can make the case for the rule of law internationally and in pursuing justice. I think the Chagos Islands case is also a testament to small states struggling for justice with international legal tools. On the domestic level, I think something that has been occurring recently and shows a challenge to the rule of law and for upholding human rights is the police and the Attorney General's criminal prosecution of foreign individuals who are illegally exploiting and usurpating properties belonging to Greek Cypriots in the occupied area, which is obviously a challenge as the government doesn't effectively control those areas. On a domestic level, despite the challenges, the Republic of Cyprus has preserved the judicial system aligned with European Union standards and ranks 31st out of 142 countries according to the World Justice Project on the Rule of Law Index. The main challenge for rule of law the last decades has been delays in civil proceedings mainly. Various reforms have taken place over the last years, and the Cyprus Bar Association always pushes for further reform. I think being a member of the EU provides external scrutiny on the justice system, and it's always helpful to get the feedback from EU institutions on various best practices and how to effectively reform our justice system to enhance access to justice and the rule of law.
Thank you so much. I personally would have many more questions to ask to such an interesting panel and after such an interesting discussion we've had. Unfortunately, we are out of time and we're far beyond our original schedule. So what I would like to ask is for every panelist to make a closing remark, a 1-minute statement, what they believe the message this summit will have to deliver to the global world community could be. So please, Ambassador Duncan.
I knew you'd ask me first. Gosh, well, I missed the proceedings for the rest of today, so I can really only speak based on what we've just talked about on this panel. But I mean, I think it's clear that we're at an inflection point right now. One of my colleagues, I think Panagiotis, said in his opening remarks that power is overtaking the rule of law. And this is something we must resist, because for any country that relies on the rule of law, for any country that does not have the power to overcome any adversary, whether that be through military or economic power, they need to rely on the rules. And we cannot let the rules-based order that we have built over the past 80 years go down the drain in the face of raw power. So it's very important for like-minded countries to stand up for the international rules-based order, and that is a domestic need as well as an international one. So if your role is as a lawyer or a judge on a domestic court, it doesn't mean that you don't have a responsibility for standing up for the rules-based order. You do it through your everyday job. You do it through the advocacy that you do with your peers. You do it through coming to congresses like this and understanding and discussing the need to uphold the rules-based order. So I hope that's been clear from the proceedings over the last couple of days.
Thank you so much. Thank you so much.
Ευχαριστώ. Εγώ κλείνοντας θέλω να ξαναγυρίσω στη μικρή κλίμακα στον καθένα από εμάς. Διότι, ας πούμε, η απόφαση που σας είπα, η πρόσφατη του Δικαστηρίου της Ευρωπαϊκής Ένωσης, ένας βασικός λόγος της αιτιολογίας της είναι ότι εμείς οι δικηγόροι, ο καθένας από εμάς, υπάγεται σε συγκεκριμένους δεοντολογικούς κανόνες. Και θέλω να γυρίσω λοιπόν στη μεγάλη σημασία που έχει για το κράτος δικαίου ο καθένας από εμάς να τηρεί τη δεοντολογία. Σκεφτείτε ότι στην Ελλάδα έχουμε 45.000 περίπου δικηγόρους και κάτι λιγότερους από 4.500 δικαστές. Είμαστε οι δεκαπλάσιοι. για τη μεγάλη πλειονότητα των ανθρώπων, το πρόσωπο της δικαιοσύνης είμαστε εμείς. Πολλοί δεν πάνε καν στο δικαστήριο μετά από μια συνάντηση μαζί μας. Άρα η δική μας συμπεριφορά είναι κάτι το οποίο έχει πάρα πολύ μεγάλη σημασία στην εμπιστοσύνη του κόσμου, όχι μόνο στη δικαιοσύνη, στους θεσμούς, γιατί οι έρευνες δείχνουν ότι όταν τραυματίζεται ένας θεσμός, συμπαρασύρει και τους άλλους. Είναι μια υγρασία που διαβρώνει και τα διπλανά. Δεν είναι ότι ο ένας ωφελείται από το ότι ο άλλος τραυματίζεται και χάνει την εμπιστοσύνη. Άρα έχει πάρα πολύ μεγάλη σημασία να τηρούμε τη δεοντολογία και νομίζω ότι έχουμε λίγο παραπάνω δουλειά να κάνουμε εδώ στην Ελλάδα. Ας πούμε, στην Ελλάδα δεν ξέρει κανείς ότι ο Ευρωπαϊκός Κώδικας Δεοντολογίας επιβάλλει να μην αναλαμβάνεις μια υπόθεση όταν δεν είσαι ικανός να τη φέρεις εις πέρας, αν χρειάζονται ειδικές γνώσεις. Πόσοι το τηρούν αυτό? Θεωρώ ότι η τήρηση της δεοντολογίας, οι καλές πειθαρχικές διαδικασίες, είναι ένα κρίσιμο πράγμα που δίνει τη δυνατότητα σε καθένα από εμάς σε ατομικό επίπεδο να δουλέψει για το κράτος δικαίου. Και το τελευταίο που θέλω να πω, αντίθετα με χώρες όπως η Αμερική ή η Αυστραλία, όπου το πέρασμα από τη μία ιδιότητα στην άλλη, από δικαστής δικηγόρος και από δικηγόρος δικαστής, είναι εύκολο και είναι πολύ πιο εύκολο από εμάς, είναι στην καθημερινότητά τους. Εδώ δεν γίνεται αυτό. Στην Ελλάδα και αλλού, αλλά κυρίως στην Ελλάδα, θεωρώ ότι κάτι που λείπει και πρέπει ακόμα να κάνουμε, και γιατί μόνο έτσι θα κάνουμε τη δικαιοσύνη καλύτερη, είναι να αναπτύξουμε μία αίσθηση κοινού ανήκειν. Ανήκουμε μαζί με τους δικαστές σε όλο αυτό το μεγάλο πράγμα που λέγεται δικαιοσύνη. Πρέπει να το έχουμε συνείδηση και να προσπαθήσουμε να το κάνουμε καλύτερο. Ευχαριστώ πολύ.
Ευχαριστούμε πολύ. Ευχαριστούμε πολύ. Justice Voutsinas.
At the appellate division, judges have to adhere to precedent. The appellate division is a court that abides by precedent. I cannot divert from the rule of law unless it's a case of first impression, even if it makes me uncomfortable. So I believe there is an obligation. There is a constitution, there are statutes, there's legislative intent, and there is case law. And everyone has an obligation to abide by that precedent and that rule of law. And that can only be found within all of you. So it's been my honor to engage in this conversation on the global level at the summit, which opens the doors for an interaction and conversation where we can exchange ideas of how we can continue to institute the rule of law. Thank you.
Thank you. Thank you so much. Brother Constantinides.
Thank you. Just to be on the best practices side and be a bit more specific, because I think the focus of this summit was on technological advances and AI. I would like to refer to the Taiwan's Digital Democracy Initiative. I think it's a really good example of how you can utilize technology and digital tools, supporting democracy and public trust in institutions. It's a collaborative platform where citizens and government exchange ideas. There's a lot of open government data, so there's enhanced government data on this platform. They combat disinformation through this initiative and also run various petitions which enhances consensus amongst the various stakeholders in Taiwan. I think another really good example of using technology for the rule of law and access to justice is definitely Estonia's e-justice system. It's considered, I think, the flagship of electronic justice, and also gives a good example of how to utilize technology in strengthening the rule of law and access to justice. I think another conclusion from this summit is that the rule of law needs constant nurturing to keep it in place. And from Cyprus Bar Association's perspective, I'd like to mention that we run a Justice for All program, which is a pro bono initiative by the Bar Association. And The Cyprus Bar Association is also engaging and reactivating its legal education program, where we go to schools and speak to students in order to give the tools to society of knowing how the justice system works, and so they gain trust in it in these difficult days we are facing. Thank you very much.
Thank you. Thank you. And thank you all for your patience. Thanks so much.